My first guest today is Best of the Web columnist James Taranto to talk about the Supreme Court's decision to take up a racial preferences case. Welcome, James.
Thanks, good to be here.
So the social issues just seem to keep coming to the fore here in recent weeks. You know, gay marriage, Planned Parenthood, it just keeps coming and coming. What do you make of the Supreme Court's decision today to look at a race-based admissions policy at the University of Texas?
Well, this is a very important case because it is almost certain to result in either the overturning or the severe curtailment of a 2003 case called Gruder versus Bollinger. This was the case written by Justice Sandra Day O'Connor that upheld racial preferences at the University of Michigan Law School. Justice Kennedy was in the dissent in that case.
Okay.
Justice O'Connor has left the court, and Justice Alito, by his opinions in other cases involving race, seems to be much more on the side of treating people equally without regard to race. And therefore, this is all going to come down to exactly how far Justice Kennedy wants to go in scaling back the Grutter case.
Okay, now that Michigan decision was actually two decisions, right? The law school racial preferences was upheld.
Yes.
But in the lower school, it was struck down 6-3. The court said they took too much into account the race of an applicant.
Right.
Correct? Okay.
But it was real. I mean, the second case, which was called Gratz versus Bollinger, didn't matter. The important thing was Grutter versus Bollinger was a license to colleges and universities, public colleges and universities, and then by extension private ones who are governed by the Civil Rights Act, to continue discriminating in favor of minorities in order to, quote unquote, promote diversity. There was no clear line between the two cases. It was just kind of Justice O'Connor being political and pretending to split the difference.
So the argument is that racial and ethnic diversity has educational benefits.
That's right.
And that it's in the compelling interest of the government to ensure that those benefits are passed on to kids. Now, of course, the problem is quantifying exactly what these benefits are. No one seems to come up with any sort of metric for explaining why learning calculus or Hamlet is dependent on what percentage of the student body is black. But that seems to be the diversity rationale in a nutshell.
Well,
correct?
Justice Kennedy's dissent in Grutter versus Bollinger was just wonderful. He went through and looked at all the numbers and showed that this was not narrowly tailored to meet the specific goal. It was out-and-out discrimination. And he really laid into Justice O'Connor, basically saying the majority is pretending to employ strict scrutiny, which is the constitutional standard for race discrimination. It's doing nothing of the sort. This is just a fig leaf, this diversity rationale. However, Justice Kennedy did say that in principle he thinks that diversity can justify, can be a compelling interest that can justify racial preferences if the other constitutional conditions are met. So the question is, does he leave open, when the court decides this case, which will most likely be decided 5-3, Justice Kagan is recusing herself, does he leave open some sort of loophole whereby universities can continue to practice racial preferences, which is basically what Justice Powell did way back in 1978, to be upheld 25 years later by Justice O'Connor and the liberal justices. I would hope that Justice Kennedy would take an approach of just saying, look, this can't stand in principle, which is what Justice Scalia and Justice Thomas wanted to do in 2003.
Right. And you referenced these old decisions, Bakke, 1978, I believe. I wanted to ask you about how the justification for affirmative action has evolved over the decades. I mean, it used to be presented as a remedy for past discrimination against blacks. Now, you could argue that you don't address past discrimination through reverse discrimination going forward, but that was the justification. It's now evolved into a sort of open-ended diversity justification.
Well, this gets complicated. What's really happened is, through a series of historical accidents, depending on who was on the court at a given time and what arguments they found appealing, different rationales are applied in different areas of the law. So the court has never held that racial preferences in college admissions are acceptable for remedying past discrimination, only for promoting diversity.
But advocates have. Advocates have.
Right, but this is a legal this is a legal case, so we have to look at what the legal precedents are. The court has held that remedying past discrimination is a justification for affirmative action in employment and government contracting. There was a hilarious case a few years ago where the city of San Francisco was sued because it had preferential treatment for minorities in contracting. And San Francisco's defense was, we have these because we, the officials of the city of San Francisco, have a history of discriminating against minorities. This is their defense, that they are racist.
Have proponents of affirmative action policies, James, in a way given up on the black underclass? Have they determined that these folks just cannot cut it on a level playing field, so we need to tilt it in their favor?
Well, I think there are two parts of that. What they've given up on is educating the black underclass in public schools. And perhaps there's an element of racial prejudice to that, but also there's very clear, there's an element of interest group politics, right? The system that we have, the educational system that we have now, is serving particularly that population very badly. But who does it serve very well? It serves the teachers' unions. And by the way, there's an element of racial politics here too, because government employment, including in schools, is one way in which urban black politicians give benefits to black citizens. So it gets that's more a political question, and it has to do with democratic interest group politics.
But it's true that, in the logical conclusion here is that if you want to solve this issue or solve this dispute over racial preferences at the college level, you should really be addressing K through 12 education.
Sure, but
you can't solve this problem at the college freshman level.
But the left and the Democratic Party have no political interest in solving this problem. They have an interest in keeping this problem festering so that they can continue getting 90 to 95% of the black vote. The only way they will address this problem is if blacks stop voting Democratic in monolithic numbers.
And we're probably not going to get a decision this term on this case, right? This is probably something the court will decide next year.
I believe they've said they'll hear oral arguments in the fall, which could mean a decision around this time next year.
Okay, but it could still play a role in the presidential election later this year, hearing oral arguments. It'll be in the news.
Conceivably. I mean, I don't think that President Obama wants to run on this particular issue because it's important to him as the first black president to have an appeal not just to black voters. I think he'll want to stay away from addressing it too directly.
It's also kind of hard for the first black president to argue that systemic racism is oppressing blacks, and that's why we need preferential policies.
Well, Obama in the 2008 campaign actually made some comments to the effect that maybe we need to take a second look at race-based affirmative action. He said, it's not really clear to me why my daughters should benefit from this sort of system. Now, as president, he's done absolutely nothing in that regard. But that was the kind of thing that he said in his effort, in his successful effort to appear moderate as he was looking for votes in the general election.